During the last few years, the topic of court specialization in intellectual property disputes has actively been discussed in legal circles. On 29th of September 2017, the President of Ukraine signed Decree number 299 on establishment of High Court on Intellectual Property, and the next day the High Qualification Commission of Judges of Ukraine announced the competition to this court. We need to increase the pace and work intensity on the creation of the High Court on Intellectual Property, which we have never had before, which does not exist in many European countries, which does not exist in many countries of the world, but some countries have such court, and almost everywhere where it exists, it is a successful project. The competition was announced for 21 vacant positions of a judge of the High Court on Intellectual Property. As the representatives of the legal community indicate, the establishment of the patent court will be a great achievement for Ukraine.
We have been going for a very long time to this moment. The field on the intellectual property has been expecting this for a very long time, and the establishment of such court will be perceived like a gift for this area because disputes itself are very complicated. However, it is necessary that disputes be viewed by judges who understand the subject of consideration. This is the first and foremost. Secondly, for Ukraine it is a huge problem as 3 jurisdictions have been involved. That means one dispute has been viewed within the civil, commercial and administrative jurisdiction.
The intellectual property has been developing, it's expanding. Now you can see that all economy, commerce, everything goes around business, and now there will be appearing new cases, in particular on website interface protection, on trademark violations at websites, the use of certain services which the companies use on sales websites. Well, this actually is a utility model or an invention, and in my opinion, the establishment of such court will facilitate a qualified solution to these difficult problems.
The creation and existence of unified specialized court, which will consider such category of disputes, will contribute to the establishment of unified judicial practice and accordingly to the effective resolution of such disputes. Therefore, I believe that right now, the creation of the High Court on Intellectual Property is appropriate. The specialization of courts is the general trend throughout the world. The practice of intellectual property disputes resolution through specialized court embraces more than 80 countries. Top countries for patent legislation are the United States of America, China, Germany and France. In Ukraine, during 2016, the courts have considered approximately 1,500 cases on the protection of intellectual property rights. Such approach corresponds to the world practice, namely, almost every developed country in the world has a specialized court which considers cases on intellectual property. Therefore, we're not doing anything new, we're not inventing anything new, we're just duplicating the most successful practice in the world of building the judicial system.
Starting from 1961, Germany has successfully established patent courts, which are duly functioning. Now on the agenda is the creation of European Patent Court, which respective legislation has already been developed, and they are just expecting the ending of the ratification procedure.
The High Qualification Commission of Judges of Ukraine has already started reception of documents from candidates who have the intention to take part in the competition to the High Court on Intellectual Property. From 1st until 28th of December 2017, candidates submit their documents to the Commission by mail. The list of all necessary materials, as well as the terms and conditions of the competition, can be found at the official website of the Commission.
I would like that exactly such people, modest, professional, worthy, have come to this court and remained in its work as much as possible in order to have trust in such court, in such people, so that the investor for whom we are so worried about, and we need to be worried because this is the reputation of the state, when investor will come to Ukraine, he should understand that he will be dealing exactly with such category of professional people.
If a person does not understand neither the specifics of these disputes nor the subject of consideration, it will rather be difficult to examine the case, because he or she will be forced to address the experts most of the time, and legal expertise will remain at our competence, based on those procedural laws and on the law on the judiciary and the status of judges.
Business will obtain specialized judicial instance, professionally consider such category of disputes. I'm familiar with many advocates who specialize on intellectual property cases, and they're actually complaining that the judge does not hear them, and the judge is not able to hear them because the judge does not understand such category of cases. We would like to remind that the judges of the High Court on Intellectual Property can be judges with a work experience not less than 3 years, advocates with work experience not less than 5 years in representing the cases on the protection of intellectual property rights in the court, and patent attorneys with work experience not less than 5 years, with cumulative experience not less than 5 years.